If you would like to learn how to eliminate your debt for significantly less than what you owe, then you should be watching this video. Depending upon your situation, we may be talking about hundreds, even thousands, possibly tens of thousands of dollars. Hi, I'm Mark Silverthorn. I hope you enjoyed this video. My name is Mark Silverthorn. I spent 12 years working as a collection agency lawyer for 4 of the largest collection agencies operating in Canada. I then changed sides and worked 9 years as a consumer lawyer representing Canadians struggling with debt. During this period, I personally negotiated hundreds of favorable settlements. In some instances, we were able to eliminate an individual's debt for as little as 15 to 25 cents on the dollar. A few years ago, I wrote a book titled The Wolf at the Door: What to Do When Collection Agencies Come Calling, published by McClellan and Stewart. The purpose of this YouTube video is to teach you how to save money settling one debt. You can do this yourself. You do not need to hire a debt settlement firm to represent you. If, however, you would like some assistance, you may want to hire a debt coach. I am a debt coach, and if you would like to take advantage of my 3 decades of experience in both the debt collection and debt relief industries, I would invite you to visit my firm's website, debtcoachsilverthorn.ca. Let's do a quick recap of the first 2 videos in this series. This video has chapters as set out in the description, which gives you the option of only watching those sections of the video that are relevant to you. If you have a consumer debt, then it might be possible for you to eliminate your debt for significantly less than what you owe. Your creditor or its authorized collection agent might be prepared to accept a one-time lump sum payment as settlement in full, provided no payment has been made on your account for a minimum of 6 months. Obtaining a favorable settlement is typically a matter of negotiation. If you are going to settle your account by paying less than what you currently owe, then your creditor is going to insist that you make a one-time lump sum payment. It is not possible to settle your unpaid account making installment payments. You should not start settlement talks until you have sufficient monies to fund your settlement. I recommend that you have an amount equal to 25% of your outstanding balance before you commence settlement talks with your creditor or its authorized collection agent. It might be prudent for you to eliminate any available credit appearing on your credit report prior to commencing settlement talks. Your creditor or its authorized collection agent will typically have access to your credit report, and it will not be inclined to entertain a settlement if your credit report reveals that you have available credit sufficient that you can simply pay your account in full by taking a cash advance on a credit card or a line of credit. If you are currently making payments on an account and your goal is to eliminate this debt by making a settlement, then there are 2 issues that you should be aware of. Number 1, the harm that this will have on your credit score and a variety of adverse consequences. And number 2, the possibility that you may become a victim of your creditor's exercise of its right of set-off. If you are going to negotiate a settlement, then you will need to identify the organization that is currently attempting to collect your outstanding account. This is the organization with which you will negotiate a settlement. The simplest method of identifying the organization that is attempting to collect your account is for you to call the main telephone number for your original creditor to identify yourself and your account, and to ask for the name of the organization that is currently attempting to collect your account. One of the issues that may arise is who owns your debt. Either your original creditor or a firm that has purchased your account from your original creditor owns your debt. Your original creditor is the firm that originally provided you with goods, services, or credit. A debt buyer is a firm that has purchased your account. The firm that owns your account may either utilize its own employees to attempt to collect your account, or it may hire a collection agent to collect your account. There are two categories of collection agents. The major category are collection agencies, and in some cases, creditors use law firms to collect their unpaid accounts. I'm now going to talk about issues that arise once you have identified the organization that is attempting to collect your account. As noted earlier, this is the organization that you are going to attempt to settle your account with. It is helpful if you do not do anything that is going to restart the clock on a limitation period. If you want to learn more about limitation periods, there are links in the description. In your communications with your creditor or its authorized collection agent, it is important that you do not make a written acknowledgement of your debt. It is okay if you make an oral or verbal acknowledgement of the debt. However, if you make a written acknowledgement of the debt, this may restart the clock on your limitation period and prejudice you. It is possible to make a written settlement offer to your creditor or its authorized collection agent if you start your written communication with the phrase, "without admitting liability, comma." Furthermore, it is helpful in the top right-hand corner of your communication to insert the phrase in capital letters, "without prejudice." The single biggest mistake that individuals make attempting to negotiate favorable settlements is offering too much money to settle an account. As a rule of thumb, I recommend that individuals offer to settle an unpaid account for an amount equal to 25% of the outstanding balance. Now, there are a couple of exceptions to this rule of thumb. If you owe your creditor less than $1,000, then your creditor will not be inclined to accept a settlement offer for 25% of the outstanding balance. Your creditor, however, will be more inclined to settle a settlement offer somewhere between 25% and 50% of the outstanding balance. Furthermore, if your creditor has sued you or if your creditor has obtained a judgment against you, then your creditor is probably seeking an amount equal to 75% to 90% of the outstanding balance. If your creditor has sued you and obtained a judgment against you, then they have a number of extraordinary remedies to recover monies from you. If your creditor has obtained a judgment against you, it can put a lien on your property, and this is essentially a GIC. And your creditor will be in a position to recover its monies from you when you go to sell the property or to mortgage it. If your creditor has obtained a judgment against you, then your creditor can do a wage garnishment. I would like to give you an example where I was hired to provide advice to an individual in circumstances where the creditor had not only sued my client but obtained a judgment against him and placed a lien on his home. I suggested to my client that he offer a lump sum payment of 25%. The creditor, who was a debt buyer, agreed to accept a one-time lump sum payment equal to 30% of the outstanding balance. In this particular instance, the debt buyer essentially wrote off $14,000 in debt and settled this account for only 30 cents on the dollar. The second biggest mistake that individuals negotiating settlements make is impatience. As a general rule, the longer that an account remains unpaid, the more generous a creditor is going to be when it comes to negotiating a settlement. It is important for you to be patient because more generous settlements should be available in the future. If you have found this video helpful, I would invite you to smash the like button. This will help ensure that more people see this video. When you offer to settle your outstanding account for less than 100% of the outstanding balance, you should not be surprised that your creditor's representative is going to insist on receiving payment in full. In the collection industry, collectors employed by your creditor, employed by collection agencies, and employed by law firms are trained to demand payment in full. It is very rare, however, that at some point that a creditor will refuse to accept a one-time lump sum payment for significantly less than what you owe. It is helpful for you to think of this process as a poker game. It is also helpful for you to think of your unpaid account as a piece of fruit at a grocery store. Your account, like the piece of fruit, loses its value over time. Creditors know that the longer that an account remains unpaid, the odds of them recovering a penny are reduced substantially. If a collector informs you that a creditor will only accept payment in full, then you can simply inform the collector that you will try back again in 6 months. If you subscribe to the Debt Coach Silverthorn YouTube channel, you might be aware that we routinely publish videos on Sundays. We recently started publishing YouTube shorts during the week. These shorts are less than 60 seconds. Our most recent short was 22 seconds. Our goal in publishing these YouTube shorts is to introduce our channel to a much broader audience. On Sundays, we will continue to publish our longer videos, which are typically longer than 8 minutes. If you enjoy watching the videos on this YouTube channel, then I would invite you to hit that subscribe button and hit the notification button. Your support will ensure that more people see these videos.